What's up, everybody? This is Attorney Davis Younts, my partner in fighting tyranny and injustice. Caleb Byrd is not with us today, but this is kind of a second installment of a series that we are going to be doing from the militarycounsel.com. And our goal in this is going to be to talk about issues impacting the military justice system, as well as just provide some background on things that are going on as we look at military justice as a whole. And this is critical, whether you're in the military, you're under investigation, you're dealing with issues or not. Issues with regard to military justice have a huge impact on good order and discipline within the military, as well as military readiness. So it's Friday. This has been an incredible week for us here at the Military Council. We've had two really significant victories that are going to tie into what I'm going to be talking about, which is big changes in the military justice system. So we had two cases this week. One was an ongoing sexual assault investigation involving an airman stationed in Texas. And it was a false allegation from the beginning. I think everyone involved in the case knew it was a false allegation, but it took almost a year of pushing back, fighting the system, fighting the inertia of the system, as well as always to believe the victim, no matter what sort of mentality that's infiltrated the military justice system. But finally, we learned there will not only be no prosecution, no charges will be brought against our client, but we have also learned that there's not even going to be any adverse action. So after a year of investigation, there won't even be any bad paperwork or anything else. So that's a huge win. The other case that I spent about 3.5 days dealing with this week was a sexual assault. 5 different sort of sexual offenses were alleged against my client, who was a member of the Maryland Air National Guard. And while I can't go into all the details of it, this case had everything we worry about as far as the military justice system. We had issues with general officers taking over the case and trying to influence the process, as well as politically correct ideas creeping in and trying to make essentially locker room humor into a sex crime, a felony level sex crime. But praise God, we were able to put on a great case. We had the opportunity to present the case to an administrative discharge board, and they came back and found no misconduct. They fully exonerated our client as to all 5 of the allegations. But each of those cases is interesting because when we talk about the military justice system, over the last really 2 decades, we've seen significant changes, and it feels like over the last 4 years during the Biden administration, the pace of change just increased rapidly. So the big change in the military justice system right now is that a lot of authority is being taken out of the hands of military commanders. Now, as an overall overarching principle, when we talk about that, what I mean is in the past, the military justice system has always worked well when commanders are in control. This goes all the way back to the Revolutionary War. This goes all the way back to George Washington. As the commander in chief, he was the one responsible for and overseeing the military justice process, the military justice system. And the military justice system works well when that is the environment that we're in. But what has happened over time is a couple of things. One thing that happened first is an overreaction to how we handle allegations of sexual assault and other sex crimes in the military. And the issue has become that we've created a system where we incentivize false reporting. So there is a huge incentive wildly within the military system to have false reports of false reports of sexual assault. And what that means is that quote unquote victims, complaining witnesses, have been incentivized to report a complaint of sexual assault. And how that happens is they are given a get out of jail free card. They are given a free pass, and there are policies in place within the Department of Defense that say, even if you were engaged in misconduct, if you are the victim of a sexual assault, then you will be given a free pass and you will be free to report the sexual assault allegation without getting in trouble for your own misconduct. Now, in theory and concept, that might sound reasonable. It might sound like, okay, what we want to do is ensure people that are victims of crimes are protected within the system, and that we don't have a system where they're afraid to come forward because they're afraid of being prosecuted for minor mistakes that they may have made. The problem is there's no checks in the system. There's no checks to say, is this a false allegation or not? And the military has developed if you are making a complaint of a sex crime, of a sexual assault, no matter what, we are going to believe it and treat it as if it is true. And even if it's a false allegation, you get a free pass for your own misconduct. Now, that may be a little bit of an oversimplification of the process, but this is in the environment that we're in. So we've had this move where we give essentially immunity from criminal activity and other misconduct if you claim you're the victim of a sexual assault. And so we have this scenario where commanders are in charge of prosecuting sexual assault cases, and we have incentivized only going forward to trial. So you have many, many cases that have gone to trial over the past 2 decades in the military that no one believed were a sex crime or a sexual assault, but it went to court-martial prosecution anyway. And the result was a high level of acquittals. In other words, all of these garbage cases that were false allegations and never should go to trial, went to trial. They resulted in acquittals. And then Congress came back to the military and said, okay, something's wrong. Your acquittal rate is too high. You must have, lawyers that don't know what they're doing, or commanders who don't know what they're doing. And so what they did is they created something called the Office of Special Trial Counsel. You'll hear military members use the acronym OSTIC. And what this Office of Special Trial Counsel has done is taken the authority away from commanders to decide which cases will go to trial, which will go to court-martial, depending on the type of case it is. So essentially, all sexual assaults and crimes of that nature will be routed through the Office of Special Trial Counsel. Now, this is a significant change, and what we're seeing so far is there are fewer cases going forward to trial. There are fewer cases going from the investigative stage into criminal prosecution, at least initially. That's what appears to be happening from the Office of Special Trial Counsel. Why is that happening? The standard is different. The Office of Special Trial Counsel is attorneys, prosecutors with some level of experience that are actually supposed to be evaluating the cases, and they're supposed to be looking at the cases and saying, is there a reasonable likelihood of success at trial? In other words, is there a reasonable likelihood that this case will result in a criminal conviction? If there is not, then the Office of Special Trial Counsel, rather than the commanders involved, get to make the decision as to whether or not the case goes forward to trial. So I do think we will see less cases moving forward to trial, but there are 2 significant consequences to this that I want to spend a few minutes talking about. The first is we've taken commanders' authority away from them. We've taken them out of the military justice process for these cases, and that's dangerous. And quite frankly, as a retired lieutenant colonel, who's someone who served in the military for 20 years, who deployed, I trust commanders. Not always, and mistakes have been made. We've certainly had issues with DEI hires and things like that. But for the most part, the military has always been a system of merit, a meritocracy, where the best people rise to the top and the best people should be in command positions. And quite frankly, those leaders, those commanders are the people that should be making these decisions about the court-martial process, because it is their organization, it is their unit, and they're the ones that are responsible for readiness and good order and discipline. So taking that authority away from military commanders is dangerous. And that's not something I am supportive. But the other problem that's happened is now we have created this Office of Special Trial Counsel manned by attorneys, not military commanders, and they're supposed to make these decisions. And my fear is over time, while we might see an initial decline in the number of cases going to trial, and cases that should never go to trial may be killed, I am also concerned that we're going to see this office become very political. This office is going to have to answer to Congress for the number of cases that go to trial, the resulting convictions, and otherwise. And I am very concerned that there will be political fallout if Congress perceives that there's not enough being done within the military justice system. My other concern is that over time, we'll be pulling commanders farther and farther out of the military justice process, and we'll be taking military justice away from its proper place in the military, which is to impact good order and discipline and readiness. and turning it into a political tool or something else. The bottom line is we don't want JAGs making decisions that commanders should be making. Certainly, a good commander is going to rely on their JAG as an expert for advice and guidance. But ultimately, we want commanders to be empowered to lead their organizations. And that's what we expect in combat. That's what we expect as we talk about military readiness and success on the battlefield. And anytime we're talking about taking authority away from commanders in any of their processes, I tend to oppose that. So now we have this new system, and we are in the world of the Office of Special Trial Counsel. So the first thing is we've taken some authority away from commanders. I'm not supportive of that. But the second thing we're going to see is this, and I think this is a significant concern for all military members, is we are going to see, I think, many more cases that are labeled or called a sexual assault, like the discharge board that I had in Maryland this week. I think we're going to be calling them sexual assaults, but they're not going to be going through the court-martial process. And my concern with that is you're going to have military members that are accused of a sex crime, accused of sexual assault, a very, very serious crime. It's going to be investigated. And then rather than being handled through a court-martial where the legal standard is beyond a reasonable doubt, where you're entitled to a court-martial panel, that is a jury where you have a real military judge presiding over that process, we're going to see the same people who are being falsely accused of sexual assault and sex crimes. We're going to see them, rather than getting the due process that is part of the court-martial process, the constitutional protections that are in place, we're going to see them undergoing investigations. The Office of Special Trial Counsel is going to look at a case and say, we don't want to go forward. We don't think we can win at trial, so we're not going to go forward. And I'm going to touch on that at the very end because I disagree with that mentality. And I think there's a baseline for justice that speaks more to whether or not we think we're going to win at trial, but also speaks to what the right thing to do is. But again, just the scenario we're seeing playing out, we're starting to see it happening with some of our cases, is the Office of Special Trial Counsel says, fine, we're not going to go to court-martial. But then the case is dumped back onto the commander for the commander to use an administrative process. And the problem is, because we've taken the court-martial tool away from the commander, we've limited the commander's ability to appropriately handle these cases. So I think we're going to see, and we're starting to see, military members who are falsely accused of a sex crime, falsely accused of sexual assault, going through an administrative process where they have very little due process rights. Yes, you're entitled to an attorney, but you don't have full discovery. You don't have Sixth Amendment confrontation of witnesses like you would in a court-martial. So you're going to be going through administrative processes like administrative separation boards and other things. And these things have a lasting impact. They can be career enders, and they can also result in a stigma being attached to a military member because their DD-214, their discharge paperwork, labels them as a sex offender, even though there were no criminal charges, there was no criminal conviction, and they didn't go through the criminal process. So this is the emerging problem that I see that we have to be wary of. So what's the lesson learned here? What's the goal moving forward? Well, for us in our practice, what we're looking at is how critically important it is when a military member is under investigation that they have good representation throughout that process so that we can prepare, and that we also begin to take discharge boards very, very seriously. I think in the past, among many attorneys and certainly among military counsel, a discharge board is just seen as an administrative process, not all that significant, not all that important. And I think often there's a lack of preparation. There's a lack of sort of serious effort being put into that process. Now, that's not something that we do at our law firm, but I've seen it. And I think we have to change our attitude towards discharge boards moving forward. So when a military member is under investigation, it's any kind of a sexual assault allegation, a sex crime, the commander is going to be forced to consider administrative separation and administrative punishment. And the military member is in some respects, a disadvantaged position where they have limited due process. And so getting an attorney involved in that process early on is absolutely critical so that we can ensure rights are protected and develop a game plan to have success in those administrative proceedings. So again, I just kind of want to summarize what is a huge change. It's a huge way of doing business in the military justice system. And the big sea change is we have begun a process of taking authority and control over the military justice system away from commanders and put it in the hands of military lawyers, of JAGs. Overall, I am not a fan of doing that. And I think that we are still waiting to see what the total fallout and consequences are. But one reasonable consequence will be that military members accused of these sex crimes are not going to have the opportunity to go to a court martial and be fully exonerated at a court martial. And I know that sounds crazy because in many respects, the process is a punishment. But what we're going to see happening, I'm afraid, is the Office of Special Trial Counsel is going to be very political, and they're going to be pushing cases that they don't think they can win back on command to deal with. And the only tools command is going to have available to them are going to be administrative tools. And those are tools with less due process, less protection for the military member, where fighting it is a whole different animal. It's a whole different strategy and ball game than what we see at a court martial. Now, Fortunately, my hope is with a new Secretary of Defense, with changes coming in this administration, we will be able to relook at some of these policies and have some sane policies moving forward. But the big change I wanted to make everybody aware of and talk about is the impact of the Office of Special Trial Counsel. The immediate impact is we are going to see less sexual assault allegations go to trial, because the incentive for these special prosecutors in this office is going to be to only take the cases to trial they believe they can win. On one side, it is good to see that actual cases where there are false allegations of sexual assault will not go forward to trial, and someone will not be facing 30 years of confinement in a military prison over a sexual assault allegation. The downside is if the Office of Special Trial Counsel becomes political, you're going to see them not doing the hard thing, not taking real cases where there are real victims forward to trial because they're afraid they can't win for some reason, and then dumping that back on the chain of command. So at the end of the day, commanders are going to be left with a responsibility, something they're responsible for, ensuring the safety, the welfare, the good order and discipline of their personnel, but we've taken a tool away from them. So again, sometimes there are things we cannot change right now. This is not a process or a system that we can change, but we can react. We can grow. We can learn as attorneys, as military members. We can discover ways that will help our clients, that will help the military system be improved. And one of those is going to be taking a more aggressive approach throughout the investigative process, getting involved early, even in cases that aren't going to go to trial, in those administrative processes, so that we can protect military members' careers, as well as ensure that this sexual assault allegation, these false allegations, do not create a permanent stain both on their military record or their civilian record after their service. So listen, that's all I wanted to share with you today as we talk about these changes in the system. Look for another video from us next week where we talk about other critical issues facing the military and the military justice process. Thanks for watching this. Be sure to follow us on social media, including my account at Davis Younts on X. Thanks for listening. God bless.
Left to men like Davis Younts to fight for these Navy SEALs.
Davis Younts, you are an attorney who has successfully defended naval officer.
Davis Younts has been instrumental in defending service members.
Davis Younts successfully defended an evangelical Navy lieutenant